You recall before we broke for lunch, you indicated that there was a preliminary internal audit report that had been availed. I confirm a document has been availed to the Commission. Commissioners, you have run out of space in file 9, so it's a little file marked Exhibit File 9, capital A. And it should have been put on your desk. Yeah. Advocate Johnson, you have it before you?
I do, ma'am.
It's marked for record purposes CJC 399 and starts at 3818. I've just received this and I just quickly scanned it. You recall that you indicated that it was received at the same time as the General Matlou Section 27.
That is what she informed.
That's what you are informed. And I looked through this, so if we could just flip, and the purpose really was to see the extent to which that Section 27 even implicates General Masomula. Looking at it, I see that it gives a background to the bid itself, and at page 3823, it is signed 29 April 2025, at the bottom there. And if we go beyond that, it seems to have an annexure, and addresses at 3824, accountability, responsibility, and distribution. It kicks off with a detailed analysis of the bidding process, and it gives all those details, the bid evaluation, and at 3838, it then makes certain observations regarding red flags and or evidence of fronting in the bid of Medicare 2420, sets out the basis for concluding there were red flags, then addresses at 3839 the various companies registered to Mr. Matlala, at 3840 registered to Mr. Van Wyk, as well as other 12 companies registered to Mr. James George Murray. Then at 3841, it makes general findings at paragraph 3.4. And they are set out there, but the interesting thing is that the conclusion 3.7, it concludes the bid adjudication committee did not exercise due care in considering an evaluation report from the bid evaluation committee. Then it draws conclusions at 4. At 5, recommendations 5.1.2, the recommendation is that the bid should be terminated. The accounting officer should seek legal counsel on how to proceed with termination. The termination of the bid is consistent with section 23.1C of the general condition of contract, which states that the purchaser, without prejudice to any other remedy for breach of contract, by written notice of default sent to the supplier, may terminate. At overleaf at 3843, it states evidence 5.1.3, evidence of procurement irregularities were observed in the bid. Therefore, the bid is currently being subjected to a forensic investigation with a view of pursuing a criminal investigation against the supplier. So, and that seems to be the conclusion. So we know this is the preliminary report is available on the 25th of April, 2025. And in terms of...
Sorry, Ms. Where do we see the 25th?
Me?
Where do we see the 25th?
Oh,
date?
that is at...
It's on the second page, Commissioner Balo, I think it's, yeah.
Second page of the report.
It's 3823.
It's also there.
Oh. It's signed and dated.
Oh, yes, thank you.
Yes, by the Acting Chief Audit Executive T.E. Mukwana and by Chief Risk Officer Major General Matlou. In fact, it's the 29th of April, 29th of April 2025. And we know from General Matlo's Section 27 referral that by the 15th of May, General Masemola had terminated that contract.
So 2 weeks later. 2 weeks after this report, General Masemola had terminated the contract.
I get it, Chair.
And remember, as Advocate Sillo said, 5.1.2 said he must seek legal counsel on how to proceed. So one must assume that in those 2 weeks, he sought legal counsel.
That is correct.
Thank you, Commissioner. So, and I know I read it very carefully. Where I land is, insofar as General Masemola is concerned, it doesn't cure the shortcomings in the Section 27 affidavit as submitted by General Matlo, because it is absolutely silent on either irregular conduct, unlawful conduct, criminality attributable to General Masemola. Is that your, and I know perhaps you only had an hour as well to go through it, is that your interpretation as well?
From the
From the
preliminary,
document
yes.
itself? Yes. Then I think that then settles the matter. And it goes back to the concession you refused to give me, and you say it's dependent on the contents of this document. You've seen the document now. Are you going to agree with me? You said it would be irresponsible, I think, to agree with me without having had sight of the preliminary, the interim audit report you have now had sight of. So, on the basis that the condition has been met, I take it won't be irresponsible to agree with my conclusions.
Let me think. We didn't finish before lunch, so maybe I'm still disagreeable. No, I agree.
Thank you.
I agree.
We had just dealt with the arrest and second intended arrest that didn't take place of General Masemola. I would like to move on. Yes, we are closing 9A. Thank you, Commissioner. Chair and Commissioners are suggesting that I move on from the issue of the arrest of General Masemola and the intended arrest for June 18th, 2026, which was not executed.
Sorry, it's Kumalo and Madondo.
What did I say? I said Masemola.
Masemola.
I'm getting everything wrong today, ain't I? I just, my apologies. There was never an intended arrest for General Masemola, General Kumalo, and General Madondo. Advocate Johnson, a document will be distributed to you. Don't mind it for the moment. We'll refer to it when the time comes, and we'll have a discussion on it. I then want to move, are you aware that after the arrest, yes you are, after the arrest, the accused applied for bail in the magistrate court, and they were granted bail. You are aware of that?
Which matter are we talking about?
In the Mukwele matter.
Correct.
Yes. And if you turn to, I think it's, if you bear with me, file 7, page 381. Page 3, no. CJC 381, page 2948. Apologies, Commissioner. It's CJC 381, page 2948. Those are the magistrate's notes taken during the bail hearing. Are you aware of the condition granted, bail condition granted by the magistrate at 2949? It's condition 3. That accused number 1, 3, 4, 5, 6, and 7 are prohibited from being at any premises of crime intelligence within the country, RSA, while the matter is pending. The fourth condition was Mr. Brian Padiachi will assist the accused with the collection of any matters or items of personal nature the accused may have at the premises, in the crime intelligence officers. I don't see everything there, but that's the gist of the fourth condition.
May have left.
Or may have left, thank you, Chair. May have left at the premises of any crime intelligence office. Now, you were asked about this condition at the ad hoc committee, you recall?
I must have been.
Let me see if my record keeping is what it ought to be.
653.
I've lost my place, but
Are you perhaps looking for page 543? It might give you a sense of where you're trying to go.
could very well be, Commissioner. Yes, it's page 543, thank you. Thank you. And it starts at 542 at the bottom. And at the bottom, Advocate Arendse, referencing some of the complaints by Lieutenant General Mkwanazi at the press conference of the 6th of July, 2025, states, now he being referenced to General Mkwanazi, makes reference to one of your investigators, Mr. Brian Padiachi. Let me put to you two allegations made by Lieutenant General Mkwanazi made in his affidavit. He said, quote, a further condition is that the accused required anything, if the accused required anything related to their work, it could only be obtained through the intervention of the investigating officer. This is in relation to General Kumalo. Then at the bottom of 342, it indicates that General Kumalo has applied for the bail conditions to be amended, but the hearing of this application to amend has been postponed on numerous occasions. Then you respond to this bail condition at page 543, and you state the assertion being that Mr. Padiachi would be allowed to have access to criminal intelligence is incorrectly interpreted, mainly because we have witnesses at CI. Those witnesses had indicated that they had been intimidated and victimized. The condition for them not going to CI was to ensure that the witnesses were not intimidated. Mr. Padiachi would not have been allowed to access any documents from CI. If after that one identified that there were documents from CI, we would have had to follow the process we had followed initially, which would have been to issue a Section 28 subpoena to the National Police Commissioner. No one would have been allowed to go to CI, engage any personnel, or take any documents. It is Mr. Padiachi who in fact would call Lieutenant General Mkhwanazi to let him know that he's going to be in the province. There are a lot of points raised in your response. I will, for the moment, not deal with the issue of Lieutenant General Mkhwanazi and Mr. Padiachi having to call him, because I don't understand what he's got to do with this particular bail condition. I'm interested in the point you make that it would be wholly wrong to have a condition that entitles Mr. Padiachi to access to CI documents. That was your view, correct?
Yes.
Are you aware that when the Lieutenant General Kumalo, I think there were 3 of them who challenged this condition, that Colonel Padiachi filed an affidavit in opposition of the amendment of that condition in circumstances where you, as his leader, knows that that condition would not make sense because Mr. Brian Padiachi himself does not have any security clearance to access information that is within the CI offices.
Correct.
What's your comment to that?
So, first of all, and that is why I said what I did at ad hoc. We have no right to enter those premises. And if, as per the bail condition number 3, that bail condition was way too wide because it talked about crime intelligence within the country. These were crime intelligence officials chair at head office. So, and the purpose for which I understood they were going to ask for that condition was merely based on the fact that there were witnesses still employed within crime intelligence and that these witnesses feared any of the accused coming back. That part made sense, but not bar them from every crime intelligence office in the country. And that the only role that Mr. Padiachi was to play was to accompany them. They would take what they needed to take for whatever reason they needed it. That is how I understood the condition was supposed to work.
Well, I guess that might be because you had discussed it in the office. Are you aware that such a condition was not even sought by the prosecutor? Even a watered-down version, as you put it, that they be allowed to go into CI offices but accompanied by Mr. Padiachi. Even that was never sought.
Sorry, Counsel, I don't follow. If the prosecutors didn't ask, who made this condition?
Sorry, say that again?
Sorry, I didn't follow. If
no, I missed your last point. Please repeat.
You say that the conditions were not sought by the prosecutors. Who sought, then how would these conditions be imposed? Because, and please, I don't mean to be condescending.
Yeah.
As a career prosecutor, we always stand up and we ask. We will suggest bail, whether we oppose bail, we'll agree to bail, and the court will ask, are there conditions? And then we say, yes, and we've either agreed to the conditions or there's no agreement, but these are the conditions. You have to give the conditions to the presiding officer who must either accept, reject, engage, and then conditions are set. So that is the purpose of my question, Counsel. I'm not doubting what, I'm trying to understand, how do we have conditions then?
Well, that's exactly what we were trying to understand, and we put the question to Colonel Padiachi. His explanation was he can't testify to that because I think by the time the prosecutor finished her address to court as regards the bail conditions, he had since left court. Alternatively, that maybe the magistrate overheard him and the prosecutor conferring in a corner, and without it being requested in open court, the magistrate then decided to add that condition. That's his explanation. Please don't ask me as to the logic of it.
I have to disagree.
Yes.
And the prosecutor, Mayor Joy Hlachwayo, is an experienced prosecutor. She's not going to be standing in some corner having a chit-chat with whoever. If there were conditions to be asked, she would have asked them. So the fact that he walked out of court should not cast aspersions on anyone in there. I am of the firm belief that, and I do not know this magistrate, I am of the firm belief that the prosecutor would have had to ask for these conditions, and they were then endorsed by the court. I do recall, Commissioner Baloy, that I think everyone was flustered after his testimony. I just don't have it. I will ask someone to get it. There was a video clip where Advocate Hlachwayo, Joy, was addressing the court and asking for conditions. And even when the court, I can't remember all the conditions that were being asked, but she was addressing the court. And at a stage, the court then asked, but who is the investigator? And she is the one who said, it is a Mr. Padiachi or a Mr. Brian Padiachi.
Yes.
That is what I took from that clip, not having my own personal knowledge. So I do not agree that even if he left, that I can't dispute, but a magistrate would not just endorse that which is not asked. It's just out of practice. I find that highly unlikely.
I agree with you. I fully agree with you. See, that is the most striking part of this condition. Firstly, we do have a clip of the prosecutor addressing the court, and we hear all her complete address and engagement with the magistrate until she finishes. And nope, it's a longish clip. We don't have the time to play it. We can avail it to you. You'll watch it at your leisure. Firstly, during that particular address, which I understood to be the application, which is the application for bail, Mr. Padiachi is visible behind her at all times.
Yes.
So I don't know which point he left, but that was his testimony. That is the first. Second, on listening to that clip, nowhere is a condition in the terms expressed ever requested by the prosecutor. The only term was, the only engagement they seem to have is about protection of witnesses, to which the magistrate asks about who the witnesses are, and the response is that they are not ready to reveal the names. There was an engagement about their safety and concern, and the magistrate was assured that that is not an issue, it's not a problem, because they are not even known. So let's not conflate the condition regarding the security of witnesses with access to their CI documents and material.
Correct.
But somewhere, somehow, the magistrates end with that condition, and specifically nominates Mr. Brian Padiachi as the go-between between the accused and their material in their offices. So, the questions you're asking yourself, I thought that I had hoped you might be able to shed light, because Mr. Padiachi's excuse is that he probably had left court by the time the condition was discussed. We see from the clip he never left court. That then brings to the fore the question again, where does the magistrate get this condition from if it was not a matter ventilated in open court?
Had to have been ventilated in open court.
But it wasn't.
Sorry.
Maybe to be of assistance, you could look at 2956. This is the judgment, the appeal judgment. If you haven't seen it before, it sets out the exchange in court. The judge in the appeal sets out the exchange on this issue of bail and the condition. And none of it indicates that the prosecutor asked for this bail condition.
If I may, Advocate Johnson,
Sure.
I think it might be helpful for you to jump to 2959, that is the judgment, under paragraph 19, where the judge, the High Court judge, then analyzes the appeal.
Before you get there, 18.3, where both counsel agree that the court did not seek submissions from them about the condition it intended.
I think that 18.3 wraps it up.
I see that.
And then the judge considers the appeal at 19.3, points out that the legal issue to determine in these proceedings, namely whether the magistrate erred in imposing the bail condition, must be assessed based on the material that was before him and the way he dealt with that information or evidence. And then from page 2960, he references applicable legal principles. And he concludes that at 2962, at paragraph 19.17, I'm unable to find any judicial basis on the evidence and submissions before the court quo for the bail condition that was imposed. In exercising his judicial discretion, the magistrate did not confine his assessment to the facts presented before the court.
It seems from your discussion with Ms. Sello that you were not aware that the prosecutor did not ask for this bail condition. Am I correct? Yes. How does it work? You would have received a report back. No? Is that not how it works? Because this is a big case. So I think, and correct me if I'm wrong, I assume because it's not a run-of-the-mill case, because of the personalities involved and the organization that is involved, it's playing out in the media. So you would have been getting reports even after court. Firstly, I would have thought when they go to court, there's been an internal discussion about this is the position we take about bail. And
The prosecutors and investigators would have, yes.
You're not part of that
No.
discussion. But when they come back, you must get a report back about
Correct.
what happened. Does it mean that the prosecutor and the investigator did not disclose to you that they got the bonus of a condition that was not asked for?
From my recollection, Commissioner Baloy, the condition that I recollect is that the accused, they raised the issue of the witnesses and that the witnesses being at head office and that there was a condition that the accused would not be allowed to go to head office and that should they want to go there, they would contact Mr. Padiachi. And that was it, because of the witnesses.
Yeah.
That was the feedback.
You see, if they told you, both of them, if they told you that the names of witnesses were raised in court, that's false. Because in fact, the exchange between the magistrate and the prosecutor specifically says, the accused do not know who the witnesses are. As the magistrate says, but how do you protect witnesses? And the prosecutor says, I have no concern about that. because we have not disclosed their names, and we are not going to disclose their names because these accused face other charges to which these witnesses are of assistance. So the names were never raised in court. And if that's the report that you got, it would be most disappointing that a prosecutor would give you that kind of report when in fact it did not happen in court. At the very least, it's disappointing. Had you known that this is a bail condition that was not asked for, what would you have done about it? Had Miss, I think you said it's Prosecutor Hlachwayo, I think
Yes.
that's her name. Had she done what I think every officer of the court has a duty to do, is if things have happened that should not have happened, in fairness to the accused, as your code of conduct says, that, you know, prosecutors must be fair to accused people as well. If she had done what a prosecutor is required to do, or an officer of the court, which is come back to you and say, I didn't get the chance to correct the magistrate for whatever reason, but you know, we got this bail condition and we didn't ask for it and I don't know what happened.
Then they have to go back to court,
Yes.
recall the matter,
Yes.
and indicate afresh, which could have happened the very next day,
Yes.
what the conditions were that the state requested,
Okay.
and that there were in fact conditions they did not request, and that the bail conditions be accordingly amended to reflect only what the state asked them
Okay.
for.
And it takes me to a question that I was going to ask you, which is, on what basis do you oppose the appeal? We know there's an appeal. You oppose, in fact, it starts off with you in the ad hoc committee saying that bail condition was obtained to protect witnesses.
Yes,
We know that's false. It
It
wasn't
is
asked for.
that small one that I
Yes.
understood, yes.
Yes, so we know that's incorrect now. You now know that, if you didn't know it before. My question was going to be to you, you oppose the bail appeal on a condition that in fact was never asked for, and the magistrate and the prosecutor in fact must explain how they got there, how the magistrate got there and why the prosecutor did not correct it. And you oppose it. On what basis do you proceed to make the decision to oppose the appeal? And maybe let me ask you, to be fair to you, had you known these facts that we've now put to you, that this condition, at best, the magistrate made it up for himself?
It's a very amplified, sorry, I interrupted you.
No, I'm saying, let me actually ask you a much more fair question. Had you known these facts now that I've just shared with you, for the appeal, what would have been your posture to the appeal?
There wouldn't have to be an appeal. There would have been the exercise I earlier indicated. The prosecutors would have had to go back to the same magistrate at the lower court and indicate that there's an imposition of a condition not either in line with what we asked or not what we asked at all. And we hereby request that bail condition be amended, because bail conditions and bail always go back to the court of first instance.
Yes.
He was the court of first instance, and so it makes sense to go there. And that is why I say that in terms of my knowledge, it was a very limited. And that is why, as I read here, I didn't understand why they couldn't go to any crime intelligence office in the country. It was just that office where there were witnesses.
Yes.
And just even on that, one should have gone ahead and said, but we cannot preclude them from every other office, but it is in this office where the witnesses are, that we were asking for their exclusion from the office.
Lastly, can I assume, am I correct to assume that had you known these facts, you would not have opposed the recusal of the magistrate?
Correct.
Okay, thank you.
Thank you, commissioners. And I accept what you say, and particularly what you say ought to have been the right approach to the issue of the removal of that condition. But what actually happened is the contrary. IDEC, through Mr. Badiachi and perhaps the prosecutor, actively opposed the amendment to an extent that if we go to file 8, and at file 8, if we go to page 3028,
Three zero.
28. That should be an affidavit of Mr. Brian Badiachi. Located it. If you go to 3029, paragraph 5, Mr. Badiachi explains the purpose of this affidavit is to inform the Honorable Court why it is not in the interest of justice to amend the bail conditions of accused 3. The confidential documents referred to herein have been declassified by the National Commissioner of Subs for purposes of enabling IDEC to conduct its criminal investigations and, where necessary, to institute criminal proceedings pursuant to these criminal investigations. Let's move on to page 3030, paragraph 7.2. Mr. Badiachi states, accused 3 is still gainfully employed as the National Commissioner has reposted her. She does not have a top secret clearance security. She does not have a top secret security clearance, which is a requirement for her to be employed as a senior manager in the Crime Intelligence Division. I'm convinced that any other tangible vetting, investigation, and processes will not change the prevailing findings that she is dishonest and has the propensity to commit criminal offenses, as evidenced by her own affidavits, which are attached to Banda's affidavit. Paragraph 8, the rationale for accused 3's application before the court raises important and relevant questions. The first being why accused 3, who is accused of committing serious offenses within a specific workplace, wants to return to the same workplace where many of the witnesses are based, and therefore she has been exonerated, or it's a question. The second question is, why does she want to return to the Division Crime Intelligence when she is fully aware that she does not have the requisite top secret security clearance to manage a very sensitive operational section of the Division Crime Intelligence at national level? He concludes over leaf at 3031, paragraph 10, and read midway. I am of the view that there is no exceptional or compelling needs or circumstances for her to return to crime intelligence. He's mounting quite a ferocious war to protect a condition that was never requested by IDEC, not requested by the prosecutor, at least in open court, and go so far as paragraph 7.2 shows that his view is it should not be amended in respect of accused number 3, and for our record, accused 3 is Mr. Josias Ligalakala. That's accused 3, and says, no, I might be wrong, that is applicant 3. This is Madondo, and says, it's accused 3 in the charge sheet, that she has a propensity to commit criminal offenses. That's okay. As if that was not enough, if you go to page 2985, same file. That is the affidavit of Charity Matlala Matlou. Yes, she is the Chief Risk Officer. You recall we came across her Section 27 affidavit. in the SAPS Medicare contract. And she, at 2986 paragraph 8, she speaks of General Madondo's rank as Major General and employed as a member of senior management. She should have a top secret security clearance. The fact that no action was taken by Divisional Commissioner Lieutenant General Kumalo since 2024 February raises serious concern, as Madondo's mere presence in the division crime intelligence poses a serious security risk to crime intelligence and the SAPS. By virtue of the case which Madondo is facing, I'm at 9, most of the state witnesses would be from crime intelligence environment. Her access being granted to the same environment increases the likelihood of witnesses being influenced or intimidated. And at 10, she concludes, there is therefore no compelling need or circumstance for her to return to crime intelligence, especially with the knowledge that her repeated applications for a top secret clearance have been denied. I suspect that Madondo has an ulterior motive for wanting to be authorized by the court to return to crime intelligence environment. Now, this resistance to an amendment of that condition has invited Mr. Padiache, General, what's her name, Matlo, to seriously impugn General Madondo's integrity, and by throwing wanton claims against her and accusations. That's the first. Second, these were filed in opposition of an application. This tells me that IDEC put up a formidable fight which would have required both human resources and financial resources. But it also had an impact in that the applicants who were seeking to amend the very condition had to obtain presumably legal services in order to have that condition amended. And all this is happening in circumstances where it ought not to have been there in the first place. I know you've left IDEC. If you learned what you learned today about what Mr. Padiache did, and perhaps others, I don't know, but at least we know his name is there and is quite active. Is there any action you would suggest be taken against Mr. Padiache? If so, what kind of action? I mean, clearly he's gone to SAPS to go solicit an affidavit from General Matlo. I don't know what she has to do with these issues, but he got it. There might be others that he also solicited to go resist that application. Now, is that not abuse, honestly? Is it not?
Out of my own personal experience, Chair, when we do decide to go to court after bail has, even the state when we want to bring in a bail appeal, we can only go, as I know the law, and maybe someone else changed the law in the meantime, we are only able to go ahead and appeal on the bail record. That's it. If there are certain aspects, be they legal or factual, personal, mitigating or aggravating, that were never part of the record, you cannot bring in anything new. And you cannot bring in anything emotive. The only thing we are supposed to have told any court, higher than the quota quo, is the quota quo erred for the following reasons, but it must have erred on the reasons as already espoused to in the lower court. These things, I'm assuming, were not said in the bail affidavit in the lower court, I would assume, and I hope I'm correct, that General Matlow also did not depose to anything in the lower court. So the action in which this part is taken is both excessive, unnecessary, and beyond the scope of what the bail appeal allows us to do. It is very prescriptive. I did learn in my young days once, I took a chance because I didn't know any better. And the judge told me very nicely, which record did you read? Because in the one I read, the thing you're telling me is not in there. And you learn very quickly to confine yourselves, Chair. So you used the word.
A different point about it, for your comment, the affidavit of General Madondo, it doesn't seem to even speak to anything that would be relevant, even if it were permissible. I mean, she's not alleging facts. She says she works in crime intelligence, she has a propensity to be dishonest, she doesn't have security clearance. That has nothing to do with this appeal. Am I correct?
Before you answer, a correction. I too hear errors. It's the affidavit of General Matlow, not Madondo. But it's about General Madondo.
Yes, thank you. Thank you, Ms. Lee. Thank you. The affidavit of General Matlow, I'm looking from paragraph 6, the kind of material, the kind of things that she's speaking to. It's all about a security vetting panel. Among the documents in the security vetting file, I note that she has 3 affidavits, and then 8, 9, pretty much nothing. And then there's a fear that she will interfere with witnesses, but nothing that says we have witnessed so-and-so, and this is the access she has to them. So it's truly, truly irrelevant, other than to create atmosphere in the appeal.
Yes, and if one wanted to say propensity to commit crime, it ought to have been raised in the lower court.
Yes.
That she did, in fact, commit crime. Yes. What were those crimes, and were they then relevant to
Yes.
the adjudication of the matter as it was in the lower court? Using the word propensity must have a basis. A crime must have been committed, relevant to.
Yeah. So it is a relevant question, or a necessary question that you not for you to answer. But what interest did she have to file this kind of affidavit, opposing a bail application where she's not involved whatsoever in a matter, and here colluding with Colonel Padiachi, because he says pretty much the same things which have nothing to do with the bail appeal. So the picture that emerges is General Matlow married in quotes to Colonel Padiachi's cause in opposing this bail application, and whoever approved that Colonel Padiachi opposed this bail application. Do you accept that's a fair assessment?
I do.
Okay.
And
Thank
this
you.
is not the Medicare matter, so I would have understood differently.
Yes,
If she had an input in the Medicare matter.
absolutely. Thank you.
Thank you, Commissioner Baloy, and thank you. Advocate Johnson, I agree with you. There is another small problem, I think. It goes back to your signing documents based on what your investigators tell you. On the 30th of June 2025, you penned, signed, and addressed a letter to the National Commissioner informing him that General Lushaba, General Kumalo, General Madondo, it's going to be projected here, General Lekalakala and General Gabela, as well as Inube, I apologize, I don't remember her rank, and Brigadier Mukwele. You state, and this, it's, if you go to the bottom, it's signed by you, it's dated the 30th of June 2025, and at the 4th paragraph thereof, you state, kindly note that none of the above named officers are allowed to enter any premises or office which forms part of the Division Crime Intelligence or have any contact with its personnel as ordered by the court. You then conclude that any further inquiries be directed to Chief Investigator Perumal, and you provide the email address. So, I don't know, perhaps inadvertently you are perpetuating this injustice. Was the letter prepared for you
It
for
was
signature?
prepared for me
Yeah.
by Chief Perumal because I wasn't thinking to the conditions, and I do see that problem of allowed any premises.
Yes.
Yes.
Yes. So,
They would have put it in as the conditions as they then saw them there
and,
and had them.
okay.
Yes.
So you would have had to work off
What they
a court
gave me.
order.
Of the court order, or what, at least the summary that they gave me.
So you are not seeing for the first time here in this hearing that actually there was this condition.
No, I see for the first time in this hearing this condition as it is. That was the summation that they gave me for me
It
to
was not
sign.
the actual order.
It wasn't the actual order.
So they drafted a letter for you, explained it, I take it, and you took them at face value and you trusted them implicitly and signed. That's about what
Because
happened.
it had to go to the National Commissioner, yes, what had transpired in court.
And once again, you didn't satisfy yourself that those were the correct conditions actually.
No, I didn't ask to look at the conditions.
Okay. Commissioners and
I think it's more, especially in the light of what you said now as you're sitting there, that this bail condition is too wide. These people are employed in head office. You may not have seen the order itself, but you sign a letter that says they may not go anywhere in the whole country. That is crime
Sorry.
intelligence.
Yeah, I didn't read it that way, in the whole country. For me, it was any
Crime intelligence
crime
office.
intelligence office, and for me, they are bound here in Pretoria. I didn't see that as in the whole country. That is why I'm saying, Chair, when I see the handwritten condition as it is, that is more explicit than what that paragraph was. It is incorrect to have asked for that condition. And I'm not sure if that's a condition that was asked for, because I'm
No,
not,
take it from us. It wasn't asked for.
okay, because
Because your investigator says he doesn't know where it comes from. That's what he told us, because at some point he left. So he doesn't say, I was in court when it was asked for. He said, I don't know. And we've referred you to the judgment, where there is this, where the judge sets out the engagement about this condition, and in fact says that was not asked for. So I think it's at least on the evidence of Colonel Padeachi and the judgment itself, the appeal judgment, we can accept that it's established that the condition was not asked for. Thank you. Thank you, Ms.
thank you. And if I could just perhaps add to that, you don't have to take our word for it that it was not asked for. The judge in the High Court, that's precisely the basis of his overturning it, because it wasn't asked for and the judgment states as much.
Yeah, it's just I am taken aback that there's a condition that was not asked for. It is not something that I have experienced or
Indeed.
engaged with other colleagues about. So
And then it's not something that you wouldn't expect to happen in any event.
not at all.
Absolutely. Okay, then I would like to move to the next issue. You have and I think we have dealt with the issue. You have an investigator. Let's start at the ad hoc page, transcript page 626. File 3.
Silo, you said 5?
File 3, the transcript, ad hoc transcript, page 626. midway that page, you are having an engagement with Ms. Ms. James.
Correct?
And Ms. James inquires from you, do you know Sunil Belochan? You say that is correct. Is he employed by IDEC? Say he is employed by IDEC. He has not been arrested or convicted on any matter that we are aware of. I take it that that comes perhaps from some previous conversation or engagement with some other member of the ad hoc committee. So possibly it's not the first time that Mr. Belochan is being referred to here. So you confirm that he has not been arrested or convicted in any matter you are aware of. Ms. James says there's currently a case. You said there are no rogue elements within this organization. Here you have a member that you have appointed. There was red flags from 2014, again in 2024. You said there is no rogue element. Whether he has been found guilty or not, there is a pending case against him registered in 2024. Your response is, if you say so, I have not seen it. Then she inquires about vetting systems in place. If we go to page 6 to 7, midway, 6 to 7, Ms. James says, can we agree that you have a member employed in IDEC that has 2 cases and the one has not been finalized and IDEC is compromised? Your response is that if there are cases, they will be investigated. Now, if you run ahead in the same file to CJC 376, that is an article at 678. 678,
678.
page 678, yes. And this article, I think it's informed by comments by Pop Crew. First paragraph states that it was a startling revelation that IDEC appointed Sunil Belochan as a senior investigating officer, despite him having a warrant of arrest for alleged fraud. The second paragraph of that page then gives the detail of the docket from which the warrant of arrest comes from. We have a witness who has testified before the commission regarding the existence of this warrant.
Okay.
Ms. James at ad hoc brought your attention to the fact that there are cases pending against Mr. Belochan. And your parting shot was that the matters will be investigated. That's the one. We have a witness who appeared before the commission about 2 weeks ago, witness N. Witness N, once again, testified on complaints by, and I use the term liberally, the Pakistani community living, is it East London or PA, that which is said, East London, I think. It is alleged that investigator Belochan is extorting monies from and otherwise dealing with them harshly, and it's a very general summary. That's complaint number 2. The third we dealt with in this hearing, which is by Sergeant Ngosi, of Mr. Belochan leading a team of 9 people, investigators and maybe others, from IDEC of the 13th of July, 2026, to meet with him in the absence of his attorney and to solicit, again, it's my own summary, testimony from him that would implicate Generals Kumalo and Masemola. So these are three independent, these are three separate complaints. At least as regards the first, you undertook in November 2025 to the ad hoc committee that you will investigate. My question is, did you ever investigate that matter in particular? My second is, upon hearing the testimony of witness N as regards the alleged misconduct of investigator Belochan, I think and upon receipt of the exhibit file, because, I say receipt, because we ventilated the issue of Sergeant Ngosi yesterday, and by then you had retired. But you received the exhibit file, and that complaint was in the exhibit file while you were still ID. Did you investigate any of these matters to determine whether or not investigator Belochan action should be taken against him? And I won't say of what kind. And if you did, what did your investigations yield? Thanks.
Thank you. Chair, if you'll just give me a moment, there's a document I just quickly want to look for in my bag, if that's fine. Thank you, Chair. On the first matter that was raised, and we call it the Pretoria North.
Yes.
The Pretoria North or Pretoria West? Pretoria North,
North, I think.
I think. On the Pretoria North matter.
Sorry, you're quite right. It's Pretoria West, cast number 97/05/2021. West, Pretoria West.
Correct.
Yes.
When we had returned, we had asked for everyone to give us feedback, including Mr. Belochan, because we need to follow up on what had arisen at the ad hoc.
Yes.
Mr. Belochan had gone ahead and on his own, through the local criminal records center, put through the fingerprints to see if there were any matters outstanding, because that is where we find outstanding warrants or outstanding matters on the LCRC. He gave a report back that there were no matters that were outstanding on the LCRC. And it is on that basis that prior to Advocate Batoy leaving office, we had compiled a report, Chair, which said that there was no one in IDAC, or investigators especially, that had outstanding cases, previous convictions, or pending misconduct. We fast forward to now, and we are faced with this issue again. And I was faced with it about 2 Sundays ago in preparation for the commission, because I see then in the bundle of documents that are sent to me is a J50. And in our legal language, it's alive. It dies only if it has 2 lines across, where the magistrate would have to say cancelled and sign. And it must invariably go to the magistrate who would have authorized it. I immediately called Mr. Belochan and I said to him, okay, what am I doing at the commission with a live warrant? Why is there a live warrant?
If I may, I do apologize. Commissioners, that would be in Exhibit File 1, page 136.
Yes, sorry. This one. And maybe before we go there, sorry, this was the document I looked for, Commissioner. When we asked him in December, January, how are we responding to the ad hoc committee? And he went ahead and on his own, got the report from the local criminal record center. It shows no illicit activity identified. It is on that basis we were able to compile the report, and I'm happy for this to become part of the record. We will share that. That is a copy. I'll give it as a pack for the Belochin matters, if that is okay with you.
But the question is, he has an active warrant of arrest.
Now, we ask, why am I looking at an active warrant?
Yes.
Mr. Belochin then indicates that this all happened prior my time, but it was in 2021. A case had been opened of assault against him. My predecessor, Advocate Hermione Cronje, had engaged with the Office of the DPP Pretoria. She had written to Advocate Mzinyati about this whole matter. And Advocate Mzinyati then responded to her. And I am prepared to share this as well. I tried to get what I could because I don't have a recollection. But on the 8th of June, 2021, Chair.
What are you looking at now?
No, it's a letter that I'm prepared to share that I had to find as support for what I say. Advocate Mzinyati wrote to the then head of IDEC on the 8th of June 2021, refers to the conduct of a prosecutor, Mr. Letwaba, that surrounds Pretoria CARES 97 of 5/2021, and that's the CARES number in question. I'll just read relevant portions as I intend handing this in. In respect of Pretoria West CARES 97 of 5/2021, I have instructed the acting chief prosecutor to request that the warrant of arrest be cancelled pending the finalization of the police investigations. I have further directed that the matter may not be enrolled without my written authorization to that effect. I will decide whether or not a prosecution will be instituted in respect of this case upon finalization of the outstanding investigations and the acting chief prosecutor's report. That is the gist of that letter that was received.
If I may, I take that. That's what the prosecutor expressed in that letter.
That is what the DPP of Pretoria expressed in that letter.
You earlier testified what a cancelled warrant looks like.
Correct.
The warrant remains active.
The warrant remains active.
And that is really the issue, that he continues to be in office investigating, arresting other people when he himself is under an active warrant.
I got a hold of that letter. I then engaged as follows, and maybe just to make this engagement shorter. I then asked him, but this was 2021. Why is Andrea Johnson faced with it in June, July of 2026? What did you do to go and find out if the warrant is cancelled? So what he had subsequently done after my asking, because he took the word of my predecessor, he went to ask at the police station on the CARES system if they could determine what had happened with the warrant and or the docket. According to him, the docket is closed, marked undetected, and this docket would have been closed in October of 2024. October of 2024? or October of 2023, but it was in that time that the docket was closed. I said to him, but that still doesn't help me. The warrant is active. Now, the reason it's not found, Chair, on the local criminal record center document is it is only found there if an investigator circulates his warrant, and that is when it is seen. I have no explanation for why the warrant was not circulated, nor do I have any explanation for why, despite there being an instruction that he cancel the warrant, finalize the investigation, take it back for decision. Warrant is not cancelled, docket is closed, and docket is filed. This is a police warrant, and the police will do with this warrant what they do with warrants that are not cancelled.
Okay.
It's not my decision to make. It most certainly isn't.
I think your decision was confronted with what you are confronting. One of your investigators has got an active warrant. He, in the course of his duties, is arresting other people. That is a problem for you as the head of IDEC. The warrant is for the police to deal with, to execute. But the question was, what do you do with that? Can he morally be permitted to be arresting other suspects out there when he himself is under an active warrant of arrest? I think.
No.
Yeah.
This matter, the police must act as they want to act.
And what does IDEC
And
do in the
IDEC
interim?
this has to go to the judge, the IDEC judge, because this becomes one of those issues.
Should it be a consideration to strip him, at least temporarily, of his arrest powers while he sorts out his own warrant? Just a thought, I'm not imposing it,
I
I'm
don't
asking.
want to say anything lest the IDEC judge think I'm trying to be prescriptive in his independent duties. It would be wrong.
You
I'm
can't
sure-
be, you're no longer a member of IDEC. You're just
No,
like me.
Trust me, every word I say, including if I breathe too hard, can be problematic.
Okay.
So I leave that to the discretion of the judge.
Okay.
Then
So-
you asked me about witness N.
Witness N, yes.
So witness N's testimony was quite harrowing, to say the least. And after that evidence, I wrote a letter to the national director wherein I indicated that the witness has testified, the record should be available at the commission, and that through the office of the national director, it please be escalated to the IDEC judge. And I did this a week ago, or a little more than a week ago when it came out. I'm given to understand that Mr. Belochin received a notice yesterday indicating an intention for him to be suspended. And I would assume it comes only out of that matter because, Chair, that was the first matter that I have escalated to the IDEC judge. So I took the steps that I thought should be taken in that time.
Okay.
The Sergeant Nkosi complaint, we dealt with it yesterday.
Yes, we dealt with it yesterday. It's about the 13th, the events of the 13th of July. It's what, 2 weeks ago?
Yes.
But like I say, you were not hearing of it for the first time yesterday because I had shared
The
that
document-
particular
the
part of the
document, yes.
exhibit file with you while you were still ID, yes.
Yes. I didn't do anything with it yet because I was coming here to the commission. But I did say to Mr. Belochin that there is allegations against him by Sergeant Nkosi, and the allegations are serious. He has a version, but that version, again, will have to be dealt with through the channel of the IDEC judge. If I take that version, I am usurping the powers of the IDEC judge because what Nkosi is raising is not a labor issue that I can deal with. And so this matter, similarly to witness N, must go to the IDAC judge. And because it came to my attention in my time, last week or week before, as the ID, I would have to escalate it before the end of this week to the national director for him to then take further with the IDAC judge, together with the issue of the live J50 warrant. However the police deal with it, but the judge would have to know about the warrant.
Okay. I would like to move on to another topic, and thank you for the report backs on those matters. In the course of consultation with the evidence leaders, we having, I think, thought that we understood the mandate of IDEC in terms of Section 7, Sub 1, capital A. A question was put to you whether or not IDEC is investigating, I'll call it generally, the Tembisa Hospital matter. And if so, where the matter was at. You had a response for the evidence leaders, and by extension, you have a response to that question for the commissioners. You provided a document which speaks to those matters, and you will address momentarily, but you highlighted the sensitive nature of that document and its contents, and requested that it not be made publicly available because it provides detail as to progress of investigations. That's a single page that now was circulated just after lunch amongst the commissioners. You've been provided with a copy, so we won't necessarily read from it to protect its contents, but you may address yourself to the position of the Tembisa Hospital investigation, who's responsible for it, and whatever report back you can give as regards its status.
Commissioners, I just also wanted to add that confidentiality, if I can use that, it's not just based on the state of the investigations. We report to FATF. All FATF documents have an embargo unless FATF allows us to release documents. This document is shared with me because I am part of the law enforcement team that writes up reports. I write for IDEC, the DPCI writes up their case studies. So this is a case study write-up for FATF, and that's predominantly the reason why we do not put it out in the public. It is part of our confidentiality agreement with them. However,
maybe for the record, if you would say what is FATF, as in the full name,
yes,
and then spell out the short
name. Thank you. The Financial Action Task Force, which grey-listed South Africa in January 2023, has had us on a watch list. And part of what we do is we identify matters that we will be presenting to them, and we meet as law enforcement every month to update ourselves jointly. SARS, where are you on this? SIU, IDEC, the different units in the NPA, DPCI, as well as detectives. And this is where we all sit and are able to glean knowledge of the work of one another. There has been a lot of questions in the media and in the public space about why IDEC is not doing anything about the Tembisa Hospital matter. More pertinently, questions in the recent past, commissioners have been raised about, so why does IDEC act on Matlala but not on Maumela? And I saw it fit to raise this with the evidence leader to quash it once and for all. The Tembisa Hospital matter, in all of its forms, in however many legs of investigation it has, whomever the persons and entities of interest are, had been referred around about 2020 or thereabouts by the SIU to the DPCI. The DPCI has always been vested with this matter. The Tembisa Hospital, whether it's Skinny Jeans, whoever they are, who's behind the scenes, whether Mamela is involved or not, etc. All of it lies within the ambit of the DPCI. And it was important because we are supposed to account to South Africa, and IDEC has been quiet, but only because this matter, as big as it is and as tragic as it is not being accounted for.
Does the SIU, only because you mentioned them, does the SIU get to choose whether a matter goes to DPCI or it comes to IDEC? What guides that decision?
I think back then it was still early days. The ID had only been created by proclamation, but there is a challenge, and the challenge is with the legislation. The SIU must refer its matters to the NPA. NPA then distributes the matters to the DPCI and in turn now with IDEC. We had to come up, government really loves papers, but we had to come up with a memorandum of understanding that where a matter comes to the NPA and the NPA is able to assess it is an IDEC matter, they then refer it to IDEC. But the SIU, because there's a lacuna in the legislation, are not allowed to refer directly to the DPCI or directly to IDEC. It goes to the NPA as a conduit, and that has to be something that must be looked at because it does take up a lot of time between receipt, assessments, allocation. I hope that helped.
That answers me, thank you.
Have you made all the comments you wanted to make on the matter?
Can I say one more time, we don't have the Mamela matter. Thank you.
Thank you. I think that came across very clear. I think I'm ready to turn to my last topic. Yes, Chair.
Ms. Solo, do we give this back to you?
The commissioners could retain it for record purposes.
Yes.
It's just the question, I think the request is that it be embargoed, so it won't form part of our public record, but the
Yes.
commissioners may have regard to it as a response to that specific question that was put to Advocate Johnson. And maybe as a matter that then the commission may pick up with DPCI at the relevant time. Thank you.
Thank you.
Thank you, Chair.
Did you say last issue?
The one I'm dealing with next.
Okay. Thank you very much.
But I haven't committed myself as regards its breadth or depth, but it is the last issue. Advocate Johnson, in your statement, your third statement, the statement of the 10th of July 2026, in response to a question posed to you through a regulation 10.6 notice. I'm at page 7 of that statement, paragraph 16. The question had been your relationship with General Khan and how well you know him. Your response was a fairly terse one, stating that you know that he's a general based at Crime Intelligence. Before you became the investigating director, March 2022, you engaged with him in meetings with other stakeholders and attended net joints or other subs meeting at which he was present, and to which you had been invited by relevant component heads, Deputy National Commissioner or Divisional Commissioner. So, according to your statement, you significantly played down that relationship. In the course of engagement, we have subsequently established that that relationship is actually deeper than as you describe at paragraph 16. And I think it was Commissioner Kumalo who informed you of testimony before this commission regarding the fact that you attended General Khan's 50th birthday, whenever that was. And I think that shed some light on this relationship, that besides a professional relationship, you have this personal one. As you are well aware, you may very well have heard, the Commission is in possession of General Khan's charts, downloads. And for that purpose, I would like to refer you to, I think it's File 9, Annexure CJC 388.
Sorry, Council, which page? File 9?
File 9, the version I have starts at 1. Please bear with me, I'll find the page for you.
I think it's in File 8.
File 83194. Apologies. Three one 3194, Commissioner. And yes, I confirm marked CJC 388. Now, up to page 3253, these are the chats between yourself and General Khan over a period. Just as a general note, would you agree that those chats reflect a deeper relationship than just being invited to a 50th birthday celebration by a colleague? You have a personal and deeper relationship with General Khan. Would you agree with that?
Yes, ma'am, I considered him a very good friend.
A very good friend. And in fact, on reading of this, it sounds like you visited each other's families.
No, we didn't.
You have been, I don't want to flight them. Personally, I don't.
Yeah, but I can indicate that there might have been an occasion where he would have invited us,
Yes.
but we have not, I have not gone to his home. He has not come to my home. We
What-
have not socialized.
what happened to the you and General Khan had agreed that you, your family, together with your parrot, will visit General Khan, and you agreed what his family would cook for you for that day.
Yes,
So what, did that not come to pass?
it didn't come to pass.
That is the kind of relationship where you have.
Where we would talk, yes. I have met him for lunch once or twice, but not at his home, not at my home. And the first time that I attended a social gathering, Chair, was at the 50th birthday, and both my husband and I had been invited, and we attended the birthday. But I have never been to his home, and nor he to my home.
I think, I don't want to flight these. They don't take my point.
Can I suggest a way?
Read it to me.
Can you just look at 3245?
3-2?
3245. It might jog your memory. 3245, right at the bottom of the page. If you like, you can go to the next page. And as you answer the question.
Oh, that for me was, that was for me saying, I can't remember what we had been talking about, but that was for me in jest where I said, I'm bringing husband, daughter, and parrot to your home for supper tonight, start cooking. We didn't go to his home for, it's, if I could just use.
It goes
in the next
further.
page. Go to the next page.
Yes. Yeah, he asked us what would we have liked to eat. I indicated what we like to eat. Yes, but we never went to his home. I'm dead serious, Commissioner. We did not go to his home. And we talked often like that about what's for supper, what you cooked. I'm coming over for supper, but you don't go over for supper. Sorry, Commissioner.
Go ahead, Commissioner.
Are we still on home visits? I
Oh,
wanted to-
wait.
3249. Chat 7, and it continues all the way to 3251.
Mr. Maybe while Advocate Johnson
Yes.
considers this, you should think about providing an explanation why you're not flighting this. We have flighted people's WhatsApp exchanges, and I think there has to be an explanation why.
There are a number of messages where they are communicating about minor children. And we've tried to do some deductions. In some places, we end up with quite a lot of blacked out parts. And the purpose of my referring to the charts is to establish a very, very close relationship with, between General Khan
And myself.
Advocate Johnson. And if Advocate Johnson were to confirm to you that theirs is a very close relationship to a point that they greet each other by stating, saying words like, "Hi, gorgeous," then it makes my point without necessarily having to use the chats. So the chats are not going to give me any relevant evidence for anything except to establish this very close relationship, contrary to what she had stated originally in her statement. Thank you.
So Advocate Johnson, if you just look at chat 5, 6, 7 on 3249, and then it continues to 32. That is a sign of people who have a close personal relationship. And you can see there that it's not an IDEC investigation. It's really two people who are friends, and this relates to a favor to him. It has nothing to do with IDEC's work. If you just look at 3249, I will just read, for example, where he wants to know who's plotting against him, and you are to assist him. And he suspects that it is the Hawks that are plotting against him, and the two of you decide to meet, and you arrange for him not to sign in the normal course, but to come in via the VIP entrance and come directly to your office without going via reception. I mean, that's a summary of it. I don't want to go into.
Yes.
That's what it shows, at least to me. And if I'm wrong, you can say
No,
you're reading it incorrectly.
So usually, just on a point of correction, usually when we do, and he's not an exception to the rule, when we do invite high-ranking police officers to the office, we usually let them use the side entrance, and you will see, even if you go now, if there's high-ranking police officials there at the head office, we grant them that entrance.
But you see here, the purpose of the visit was to come and see you
Yes.
a personal matter.
And he did.
Yeah.
And it was a personal matter, and the
Advocate
matter-
Johnson,
Sorry.
if I may, with your leave, if I may, I have argued against projecting these messages because they have a lot of personal material involving, children. And I now have a difficulty with your response to Commissioner Kumalo's question. What Commissioner Kumalo refers to is not how VIPs visit your office. He wasn't coming in his capacity as a VIP. He was coming in his personal capacity, requesting a favor from you regarding suspicions that he's being investigated by the Hawks and the like. And from that conversation, one picks up that the two of you are planning at some clandestine meeting. You end up, because of diary issues, you end up inviting him to your office. And then to avoid a record of the visit, you suggest he use that entrance. I beg of you, please don't make me do it.
No, I'm not disputing that he used the entrance. I'm telling you, ordinarily it was done. Here, he did come to visit me. And unfortunately, when he did come to visit, it turned out it wasn't anything to do with the Hawks, but he had an issue about somebody plotting against him. It did turn out that it wasn't the Hawks. I want to make that clear. But it was...
The point is, this is not a VIP visiting IDEC office.
No, this was my friend.
This is a personal visit by a friend, and when you say to him, come via VIP entrance and don't sign in, you're not doing that for a VIP coming in his official capacity. You're doing it for your friend who's coming there to discuss personal issues.
I accept that, Chair.
And that is the whole point, to demonstrate that you have a very close relationship and the lengths you'll go to accommodate one another. I referenced how you address each other at times, either calling each other gorgeous, you tell each other how much you miss each other, and that's yes. Dearest. Okay, now have we established the relationship? It's a very deep and personal one.
Yes,
And a very close one.
correct.
So then,
Can I just add that what also seems to appear from this personal relationship is you also discuss, as friends, close friends, you discuss things that have to do with your work. For example, you've mentioned the Hawks issue. I'm looking at page 3243, where he wants you to tell him who said something, and you say, I will tell you when I see you. For now, be smart, and it's this second part that I'm reading that can be a source of concern. You say, for now, be smart about who you trust at work. Please don't say anything to anyone about you had someone is out to get you, because you could be talking to the culprit. So you and him are discussing matters that have something to do with what's happening in his workplace, and you're advising each other, and you're reporting to each other. That's what that message is. Okay, thank you.
And if I then may conclude on that note, it goes further, and one picks up from the charts that both of you have a very close relationship with General Sintumule.
Yes, well, I don't know how close his relationship was with her, but I had a very close relationship with her.
No, you must be aware, because when General Sintumule, according to this chart, was down with COVID, you and General Khan were planning what you should cook for General Sintumule, some dal soup and other fancy soups. And there were complaints that she's not picking up. You advised, no, she's not picking up because due to her level of incapacity, she was advised to switch off the phone. Then he comes back to you at some point, I eventually managed to talk to her. So you do know that he too has got a close relationship with General Sintumule, and the issue is that both of you have this relationship, and you are both concerned when she contracted COVID.
Correct.
Okay. Now, all this is relevant to the testimony of witness, I've run out of alphabet.
Witness Rulofse?
Witness O.
Oh,
Witness O, thank you. Before we get to witness O, you will recall that on the 7th of July, 26, the commission issued you with a subpoena requesting that you submit certain documents. And that subpoena is dated the 7th of July, 2026. I think you've been provided with a copy. The request there concerned certain dockets. Firstly, it was 1.1 recopying an affidavit received, a copy of that affidavit received by IDEC regarding Brigadier Mukwele's appointment. The second was all emails and or other written communication between yourself and witness O, stationed within the Division Crime Intelligence, on or about the 4th of July 2018 regarding the complaint lodged and criminal case opened by Brigadier Petle against General Feroz Khan for an alleged assault. The third request was in respect of dockets into the investigation of Mr. Inabath Kistia. I apologize if I mispronounced.
Ibanat Kistia.
Ma'am?
Ibanat Kistia.
Ibanat Kistia, thank you. And the last was dockets in respect of investigations into General Masemola's and General Mkwanazi's alleged receipt of the Louis Vuitton bags from a sub-supplier. So those were the documents requested of you. You were able to provide all the documents requested except for the emails and the written communication between yourself and witness O regarding an incident of around July 2018 involving General Khan, in which he is alleged to have assaulted Brigadier Petle.
That is correct.
Your explanation for failure to provide that information was that this goes back to 2018 or 8 years ago, 7, 8 years ago, and that your emails do not go that far.
My
And
Gmail.
Your Gmail doesn't go that far, and therefore you are unable to retrieve any record of communication between yourself and witness O. I then informed you that witness O has made available certain documents and emails, and I gave you her complete bundle regarding this matter, which is what she testified to, and I asked you to consider whether, upon consideration of these documents, is there anything you dispute, that you take issue with, that although you don't have your own, you do not recall being correct and accurate. And you led me to understand that you have no basis to challenge the accuracy of the documents provided by witness O. Am I reflecting your position correctly?
Correct, because I didn't have my own emails, and I didn't have a recollection. I can't dispute what she had.
What you recalled was the act itself that witness O testified to, and that was the act of your sharing the docket in respect of Brigadier Petle's complaint with General Khan. You recall? You admitted at least having that recollection.
I had a recollection, as I explained in our consultation, that I had shared documents with her. It is when you showed it to me that I realized what it was that was shared. I just wanted to correct. I didn't dispute what was shared.
Yes.
I could not recollect what was shared, and because of her record, I was able to look at it and confirm.
And we engaged about the contents of the exhibits of witness O's annexures, including the statement by Mr. Barry Bateman explaining the circumstances under which the docket was shared with Mr. Khan. At the time, you had an explanation for what transpired there. So, and I point that out to state that the fact that you have an explanation as to what transpired based on documents you did not give means that they triggered your memory. Upon considering and reading the papers, your memory was triggered and you remembered what transpired. Am I correct thus far?
Correct.
And lastly, you indicated that you cannot shed any further light because of a non-personal relationship you have with General Khan. And you expressed your relationship, at least to me, during consultation in the same terms that you have in your statement. But we know that's not correct. We've established that this is a very, very close and personal relationship. So I say, you must know why and under what circumstances you shared that docket with General Khan. It cannot be, I don't remember because I don't have such a close relationship with him. We've established that cannot be a basis. You've had these documents for 2 weeks now. I'm sure you have read and reread them and are able to assist.
Chair, it is. Sorry, if you'll just let me.
Oh, if you are looking for the documents, it's Exhibit 1, CJC 368, starting from page 1.
Yeah. Now, I was just looking for my supplementary statement
Your supplementary state to the commission.
to the commission.
Have you located it?
We have located
Okay.
it. And commissioners, it is in file 1, and I do not wish to belabor a point. I have read this into the record. And at the stage where we are, and I'm expected to perhaps respond and answer a question, I just wanted to indicate, Chair, that and it would be on, there's a red number 2 on the page, and it would be the supplementary dated the 20th day of July, Chair and Commissioners. Chair?
Yes, please do.
Sorry, I proceed at paragraph 5, where I read on day 1, and if Chair would allow me to just reiterate. I said the notice requires me to deal with allegations against me testified to by Colonel Kobus Rule Officer, Captain McLean, and Witness O. The allegations, as summarized, implicate me in alleged criminal conduct. The allegations are contained in a docket, which is now with the NPA for a decision on whether I should or not be prosecuted and further handling. That this is so, Chair, was confirmed by the NPA on the 10th of July 2026, as well as by the witness McLean when he testified on that day. Now that the matter is before the NPA on the basis set out above, Chair, for a decision on whether I should or not be prosecuted, various consequences emerge. One of those consequences of the need of that are the need for me to have my rights protected. Thus, when I testify on those matters, should I be called upon to do so, Chair, I will humbly exercise my right not to incriminate myself under Section 35(3)(j) of the Constitution of the Republic of South Africa, read with Section 3(4) of the Commissions Act of 1947. These instruments guarantee my right against self-incrimination. If I could just read the last paragraph then, Chair. I hold the view that the Commission's fact-finding mandate does not override my constitutional protection against self-incrimination under any circumstances. And it is for those reasons, Chair, that this affidavit is submitted to place my position in regard to the testimony of the witnesses identified above formally before the Commission.
Two things. You say you were informed that the matter is before the DPP to decide whether or not to prosecute. Is that correct?
That is correct.
Or to proffer charges against you. So that decision is not in yet. It's not there. Correct? There is no decision to prosecute right now.
There is a docket that has been sent for prosecution with its evidence, meaning that a decision must now be made, Chair, on whether or not I should be prosecuted.
And I maintain there is no decision to prosecute. There isn't. It's awaited. That's the first. And if the decision has not been made and you are not under prosecution, I'm sure you appreciate you cannot invoke the rights set out in Section 35 of the Constitution, because those are the rights of an accused person.
Correct.
Okay.
That I do invoke the rights of the Commission.
Indeed.
And as I appear before the Commission,
Indeed.
Meselo, I therefore invoke those rights, as those rights are also set out to protect me in terms of my right not to incriminate myself.
I have lost my note here, and you rightly refer to Section 3(4) of the Commissions Act. But you know, it must be read with the regulation. You are
Yes.
aware that anything anyone states and testifies to in the commission that has the potential to self-incriminate cannot be used against them in any subsequent criminal proceedings.
It can, however, be used by investigators, as has been the case, to roadmap further investigations against you, to enhance and bolster their case.
My question remains unanswered. There is that guarantee that anything you say in this commission cannot be used against you in subsequent criminal proceedings. How that information can be used is the second part, and we'll deal with it. But what it cannot do, that information can be used against you. Things that you uttered, they can be used against you. It's a legal position. You have to accept that. It is what it is. I quite appreciate the risks that you highlight. We'll get to them. But you have to accept that that's what the law provides. Advocate? No, the commissioners can multitask. They dig through papers while listening.
Sorry, Ms. Silo, yes, Section 35, 3J refers to an accused person. But does the issue of accused person apply to Section 3, subsection 4 of the Commissions Act with regard to the privilege against self-incrimination?
No, I distinguish between the two.
Yes, yes.
Here, in her affidavit, she's raised both.
Yes,
Section 35 of the Constitution, and I say that doesn't apply in this case because she's not an accused.
Okay.
So she can only resort to 3(4) of the Commissions Act.
And then you raise the issue that such evidence
Exactly.
cannot be. But what about the point of derivative evidence,
And I think this is...
which would be maybe quite prejudicial under certain circumstances, depending on what has been derived, even if they don't use what a witness may themselves have said. But
Which is the second point she raised, and I said I distinguish
Yes.
between her acknowledging that there are those provisions in the law. She mentions precisely the issue that it may provide a roadmap for future investigations, precisely to ensure a successful criminal prosecution. So I say that is the second leg. So the chair is slightly ahead of us. We were still recognizing that what she says by law ought not to be used against her. It's not lost on me the value of whoever wants to initiate criminal prosecutions to follow the evidence of the commission and perhaps have a thinking and an investigation angle that they would otherwise not have had to arrive at the very conclusion that the Act seeks to protect the witness against.
also, perhaps you will again say I'm already ahead. I'm thinking, under what circumstances then would this privilege work in practical circumstances if a witness can always be told, but what you have said cannot be used against you? Wouldn't that bring to naught the very entitlement under Section 3, subsection 4?
Yes, but the witness in her statement suggests that any issues pertaining to, I'll say, witness owes evidence, she cannot respond to. So her invocation of that section is way too wide.
Yes.
I think she's entitled to say, I cannot answer maybe for fear of self-incrimination, but she may do so only in response to a specific question. Her affidavit suggests don't ask me anything.
Yeah. No, yeah,
So
no, no,
that
no.
is the practicality of
Yes,
it
yes,
as I
yes.
see it, Chair.
That I get, which is why we engaged in the rather schizophrenic approach, which I think was forced on us by circumstances with Mr. Mukhodzi. It was question by question, and he raised his entitlement not to incriminate himself.
And
But
that's exactly what I seek.
We still went through the process, and I felt like dying. But that was that.
I shall not be the cause of your death, Chair, I promise.
No, no,
I'm trying
no,
to.
no.
I understand.
I've
I
just
understand.
made the point that I understood why we had to do it.
Yes.
So, which automatically means that even in this instance, I understand why it should be done. Yeah.
In fact, I think we are about all running on empty now. It's an approach I would prefer not to have to engage in. It is laborious, and at the end of the day, it achieves, I think, for purposes of the commission, very little, if anything.
In this case, actually, I agree with the point you've just made.
Yes.
In this case, Advocate Johnson, witnesses have given what, on the face of it, appears to be very strong evidence that you did share the docket with General Khan. Very strong evidence. What could have countered that would have been testimony from you, which, as we now see, you are not willing to do. Without contradiction, that very strong evidence may lead to a conclusion by us that those witnesses were telling the truth.
I understand.
I hope you understand that this has nothing to do with the unacceptable drawing of inferences from your failure to testify. That's not what I'm talking about. What I'm saying is the evidence on its own is so strong that if not countered, it may easily lead us to the conclusion that you did share the docket with General Khan.
I understand.
Yeah. So, which perhaps may obviate
Absolutely.
the need for us to go through this laborious and painful exercise.
Indeed, Chair. It's too horrific to contemplate. I too wouldn't want to go through it. But then it goes further as regards inferences that we suggest be drawn by the Commission as all the evidence tendered by witness O must therefore be accepted, particularly in circumstances where you were provided with an opportunity in this Commission to contradict any aspect of her testimony. If you don't, then the Commission will have no basis to reject any suggestions and any conclusions she could potentially have drawn from the evidence that she has tendered. Are you happy with that?
I understand. May I ask the chair just for a 5-minute indulgence, just to speak to the legal team?
Thank you.
And then we also would like to make this as painless as possible. But
Thank
I hope that there's an appreciation
Yes.
that there are rights that I would like protected.
Thank you. Will adjourn, will come back when we are told to. Let's adjourn.
Thank you, Chair.